Hello, I'm Tyler Smith in Lewis Thomason's Knoxville office, here on our Wednesday Wisdom series to provide some insight on workers' compensation topics. And today we're focusing on the importance of properly preparing and filing the Form C-41, known as the Employee's Wage Statement. Now, completing this task can seem tiresome at times, but this document is very important because outside of the employee's actual injury and medical impairment rating, the wage statement and the calculation of the average weekly wage is the single biggest indicator of what the employer's exposure will be for temporary and permanent disability benefits. And what you're going to find is that if that number is calculated improperly, often that error is going to come back and bite the employer much more than the employee. Now, the wage statement is this form provided by the state where the employer lists the claim information at the top and then is asked to list the wages of the employee in the pay period for the prior 52 weeks, if applicable. So the first thing the employer is told to do is to list the wages of the 52 weeks prior to the date of injury. We're not supposed to include wages that were earned on the date of injury or afterward, and we want to go back to the pay period prior to the work injury and see if we can list wages 52 weeks before that. And why that's important is because our statute tells us that if the employee is taken off work by a treating physician and entitled to temporary disability benefits or receives a medical impairment rating and is entitled to permanent disability benefits, those benefits are going to be calculated by taking 66 2/3% of the employee's average weekly wage. We commonly call that number the compensation rate, and the easiest way to calculate that is by taking the average weekly wage and multiplying that number by 66.67%. If the employee has worked less than 52 weeks prior to the work injury, we're told to divide the total wages earned by the total weeks the employee actually worked. For example, if you had an employee who made $50,000 during the 52-week pre-injury period, but was off 2 weeks on an unpaid leave and received no wages, he would take out those 2 weeks, and that would leave you with $50,000 divided by the 50 weeks that were actually worked. That would get you an average weekly wage of $1,000 per week. Taking that one step further to find the compensation rate, you would take the average weekly wage of $1,000, multiply that number by 66.67%, and arrive at the compensation rate of $666.70. If the employee has worked less than 52 weeks, there is a preference in the statute to use the employee's actual wages, so long as that calculation is just and reasonable to both parties. Now, what number of weeks is enough to be just and reasonable will need to be determined on a case-by-case basis. But we do have some case law indicating that as little as 6 weeks may be enough under the right circumstances. Our statute also tells us that if the employee has been working for such a short amount of time that it's not practical to calculate the average weekly wage, you can use the wages of a similarly situated employee. It's important to remember that the employer has the burden of producing and preparing the wage statement form. This should certainly be done before temporary benefits are initiated, but at a minimum, the employer is going to have to produce the wage statement as part of the mediation process, or if you're asking for a settlement to be approved by a judge. If you're in a litigated situation and the employer fails to produce a valid wage statement, the court may have the authority to issue an award for benefits based on the maximum compensation rate that applies on the employee's date of injury, which could make a difference of tens of thousands of dollars if the actual wages the employee earned would have yielded a lower compensation rate. As a practical matter, the average weekly wage, if it's calculated incorrectly and the employer overpays the employee temporary benefits, it may be difficult to recoup that overpayment in the form of a credit against a permanent disability award or trying to get the employee to pay back money that he or she has already spent. Our courts may also not be very sympathetic to an employer who's made that error, so it's important to prepare the wage statement accurately on the front end. A lot of questions can come up when you're preparing a wage statement or calculating an average weekly wage, and many of those questions are very fact specific. If you have questions about these issues or any other workers' compensation topics, please give us a call or email and see what we can do to help. I'm Tyler Smith, and thank you for listening to this Wednesday Wisdom video.